Hello and welcome back to Heights Library's podcast, Unpacking 1619, where you can explore the interviews we've collected with scholars from around the country, in which we unpack topics relating to race in America. I'm your host, John Pichet, and I'm thrilled to share these interviews with you here. On today's episode, I'm joined by Cedric Powell, the Wyatt, Tarrant, and Combs Professor of Law and Distinguished Teaching Professor at the University of Louisville, Louis D. Brandeis School of Law. We discuss his article, The Post-Racial Deception of the Roberts Court, in which he argues that the supposed colorblind rhetoric of the Supreme Court masks an agenda to strip precedent, history, and ultimately reality away from the racial history of the Supreme Court and America itself. Here's our discussion from July 7th, 2025.
Thank you very much. It's good to be with you. I'm Cedric Merlin Powell. I'm professor of law here at Howard University School of Law, and I'm just completing my fourth day as the newly appointed Associate Dean for Academic Affairs. So it's been quite a ride.
Well, congratulations on your new appointment, and I hope it goes well. We're going to discuss your article from late last year, called The Post-Racial Deception of the Roberts Court. Could you give us a brief overview of what you hoped to achieve in this article and how you came to be interested in the subject to begin with?
Oh, I've been interested in this subject for years. If you look at my scholarship, and I just wrote a book about 2 years ago called Post-Racial Constitutionalism in the Roberts Court. This article comes out of that because all of my work really talks about neutrality. And what I mean by neutrality is that you have the Supreme Court as a judicial decision maker, and it's supposed to be neutral, that's fine. But underneath that neutrality, there is an agenda to advance and perpetuate inequality. And that isn't like the court coming out and saying, we're going to do this and totally undermine democracy. But what I'm getting at is how the court approaches its decision-making. It always gives a neutral reason for an unequal result. So you can take any of the cases. And I'm doing a recent article on the Brown decision, but this is a good precursor to that, because in this piece, I try to talk about how the court espouses this notion that it's really upholding equality, making everything open for everyone. But if you unpack that, what the court is really doing is advancing its own agenda. And that agenda is colorblind constitutionalism, another form of neutrality, saying really that everything is equal. And when we do consider race, we have to do so in very narrow circumstances. But the SSFA case, Students for Fair Admissions versus Harvard and University of North Carolina, takes that to another level and says, oh, we really didn't mean that. We really don't want to talk about diversity. Diversity divides us, because whenever we talk about race, we set up this conflict. And what we really should do is just be completely neutral. At first, the court would say neutrality meant using race in very limited instances where you can say that, well, the state did something wrong, we want to correct it. That's clearly identifiable discrimination. And so we may be able to use a race-conscious remedy there, or we may even be able to use it for something called diversity. But this case is devastating because it says diversity is no longer a compelling interest. All we're doing is talking about race. Let's be completely post-racial. And that means we erase every consideration of race out of any type of decision-making. And when we do consider race, the court is going to say it's unconstitutional. So that's what I was trying to get at, this whole progression. And the recent affirmative action case is really the culmination of years and years of picking away at what we call diversity, and the court has completely shifted that to post-racial constitutionalism.
Yeah, thank you for that overview, because I think you bring up a couple key concepts to your argument, which I want to unpack. And the first one is that idea of a post-racial deception in the court. And there's a phrase you use in the article, which is turning everything inside out, flipping it around so that what we think of as affirmative action now means something else if you take race away from it. And I would love for you to begin by kind of outlining what this post-racial deception is and how Roberts in particular, but others we'll get to later, really have defined this as the mood of the court. I think they would say it was colorblind, but mood is maybe the wrong word, agenda of the court.
Right. So you could really sum it up in that one phrase that Chief Justice Roberts uses maybe 15 years ago in the Parents Involved case, that the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. That's circular, that's inside out. It seems like you're discriminating when you consider race as one of many factors. So what the court does when it turns things inside out is to say that whenever we consider race, race must be predominating in the decision-making that undermines the process. And so that is the discrimination. No longer are we talking about eradicating structural inequality or positive inclusion. The court will now say, well, that is trying to achieve a racial result. That is trying to achieve racial proportionality. That is trying to make people make choices upon race, and that is unconstitutional under the 14th Amendment. And so I talk about in the article also something called formalistic equality. And that's where the court says, well, everybody's already equal. And if we get the government into this process of picking and choosing winners and losers on the basis of race, we are violating the Constitution. Now, that's an interesting argument, and that turns the 14th Amendment inside out as well. That's a notion of inversion that I call it. You turn it inside out. So the 14th Amendment is one of the Reconstruction Amendments and was designed specifically to make sure that African Americans who had previously been enslaved, fully emancipated, could enjoy the fruits of full citizenship. So we eradicate slavery under the 13th Amendment. We give equal citizenship due process under the 14th Amendment, and the 15th Amendment gives the right to vote. So those three together, that constitutional trilogy, is designed and is race conscious to open up society so that everyone can be equal members. And so affirmative action comes right out of that. The Reconstruction Amendments are a form of affirmative action. But the court, particularly Chief Justice Roberts, and notably Justice Thomas, has turned this inside out. So any consideration of race is discrimination. Colorblindness even isn't really a concern now because you'd had a Rehnquist court or someone like Justice O'Connor trying to balance things and say, well, maybe in this one instance, if you can show that it's narrowly tailored and it can fit some compelling interests like diversity, Justice Kennedy would articulate that. But now the court has completely shifted. So discrimination means affirmative action. And the way that this decision was constructed is really masterful. You had Asian Americans and whites advancing in a reverse discrimination claim. That's a term of inversion as well, turning the original principles of affirmative action inside out and saying that white people are discriminated against and that Asian Americans are discriminated against. Now that's interesting because it's funny in that decision that Asian American voices are very silent, if not non-existent. And I have a colleague, Vinay Harpalani, who writes on this area, talking about how Asian Americans are erased from this picture. And so while they serve as a proxy for whiteness in terms of advancing the goal of undermining and eradicating affirmative action, they come up short in terms of what they should be gaining from this program, this initiative. Yes.
Yeah, and I want to get into the details of the case in a minute, but I want to unpack your idea of formal neutrality. So we've kind of hit on reverse injury and what we were just talking about. And I would like to tie it together with the idea of formal neutrality, where you kind of outline three different things that are used to kind of achieve this race neutral
Right.
state.
So you want me to talk about rhetorical neutrality? That's it. So again, that runs through all of my work. And so I believe that you can take any race decision and it has these three elements. There's a historical myth, there's a definitional myth, and there's a rhetorical myth. And so if you take any of the U.S. Supreme Court's race cases, they have those defining features. Now, they may do it differently based upon the case and the issue, but they're always working out how to explain inequality in such a way that is natural, because they don't want to deal with race anymore. It's completely post-racial. We've transcended race. So, and you can trace this back all the way to the late 1800s when we're talking about the Reconstruction Amendments. The court there was doing the same thing. So I do this analysis in the new book that's coming out on the Crookshank case, the civil rights cases, Plessy versus Ferguson. All of those are examples of rhetorical neutrality. So first, the historical myth. The court will uniformly either rewrite history, revise it, or ignore it. And so this historical connection between the present day effects of past discrimination is completely erased from the U.S. Supreme Court's race jurisprudence. So if you don't have a history of discrimination, it's really easy to ignore it and then say any use of race is something that's shocking and undermines societal tranquility. That's the historical myth. Next, you have a definitional myth. So after you say, well, the history really doesn't support this type of discrimination, now you have the court saying, well, how do we define it? And the court across the board has defined discrimination so narrowly that it either does not exist, or if it does exist, you can only prove it in these very, very narrowly defined instances. And so an example of that is the civil rights cases. That's an old case, 1883. And the court says Congress really doesn't have the power to impose its will on private choices. You can't undermine social conventions. And it makes the extraordinary comment that any discrimination that is occurring is really in the mind of African Americans. So why are you belabored? There's no state action here. And so that's another doctrine that sets up a really difficult burden of proof in terms of defining whether or not the state has discriminated. So the definitional myth is very narrow, and its modern day interpretation is a case like Washington versus Davis, 1976 case, but it says that you have to prove that there was clearly identifiable discriminatory intent on the part of the state. And so there's a lot of disproportionality in inequality. And the court says, yeah, that's fine. That might show us something circumstantially, but you really haven't shown us that the state was actually intentionally discriminating against someone. So, it's very difficult to advance a discrimination claim. So the discrimination is defined so narrowly that it's very hard to prove. And then after you ignore history, after you define discrimination so narrowly that it doesn't exist, then you rationalize all that by saying, oh, all of this is very natural. And it's very natural because we want to be in a post-racial world. And if we go down the road of exploring and unpacking all of these underpinnings of race, we are just going to balkanize. We're going to go into our own separate groups. It'll be tribalism based upon race, and that leads to societal unrest.
Yeah, I think that those are powerful definitions to think of these cases. And I'd love for you to apply them to the case that the paper kind of deals with, which is the Harvard case against the Asian students who sued Harvard. So could you tell us what that case was, how it worked, and what the outcome was? Because it I was appalled to find out how the white students were able to prevail through something which seems to defy logic.
Yeah, well, that's another aspect of neutrality. And I've written before that the court really favors reverse discrimination cases because they're the perfect vehicle to articulate this notion, not of colorblindness, but post-racialism. We shouldn't even be considering race because it imposes burdens upon whites because you are trying to contrive a racial result that is unfair. So the SSFA case was brought on 14th Amendment grounds and Title VI grounds. Harvard is a private institution, so Title VI would apply to that. And then the 14th Amendment applies to University of North Carolina, which is the one of the oldest public institutions. So that's a perfectly crafted litigation advanced by Ed Bloom, who is a conservative group. And they bring this claim saying that the system really favors people of color, primarily African American and Latino, over white and Asian American students. And there's a whole long discussion about this, but essentially they are challenging this notion of diversity. And you mentioned how mind-boggling this decision is. This is, again, an example of rhetorical neutrality. Court completely rewrites precedent. It sort of ignores the result in Bakke all the way leading up to Fisher 1 and Fisher 2. And just recently in terms of Supreme Court litigation, just 8 or 9 years before, you have Justice Kennedy saying, well, race can be considered. We want you to consider race neutral alternatives at first. That was always his analytical posture. But race can be considered. And then there's this case in Fisher where he says race is a factor of a factor of a factor. We're not predominating a racial decision, but we know it exists and we know it's part of the decision-making process. And we want schools to have the autonomy to make those decisions. And that's something that's rooted in the First Amendment, this notion of diversity. But the court completely obliterates that. It spans what Chief Justice Roberts does in Parents Involved and says the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. First, it says, this is an example of the definitional myth. First, it says, we've only said that we can use race in 2 different instances. And this is really interesting. They completely ignore diversity until they want to overturn it. And they say there's only 2 instances in our previous cases that have recognized a permissible basis for using race-conscious remedies. One is if we have clearly identifiable evidence that the state discriminated. And then the other is to prevent riots in prisons. Absolutely extraordinary. That had never been there before. The other prong we all know is diversity. But the court says, no, we don't even know what diverse. So one reason why Justice Thomas is so useful to the court is for the last 10 or 15 years, he's been saying, I don't know what diversity is. What is that? Is that educational enhancement? Is it racial profiling? Is it advancing a particular racial result? What is this thing called diversity? And so his concurrence sort of builds upon that. And you take that in conjunction with the majority opinion, and you have almost a complete erasure of the anti-subordination principle. Justice Thomas recounts the Reconstruction era as a time of sort of immigrants. And we're looking at Irish American immigrants. We're looking at people coming over. The Freedmen's Bureau really wasn't for African Americans. It was just an immigration agency. So he neutralizes everything, takes race out of it. And then when you do that, any mention of race is unconstitutional and discriminatory. So the decision is devastating. It says diversity isn't a compelling interest. It says you can't use a race to burden one group simply because of race. It says that there's no logical stopping point when we use race. And even though this is ahead of Justice O'Connor's 25-year aspirational limit, the time to stop is now. We've gone too far, and that undermines American democracy. So really, the court is saying we're completely post-racial now, and any consideration of race is unconstitutional.
Yeah, and the way it looks on the ground is that these Asian and white students win on the basis that using affirmative action prejudices against them by privileging a group of people who it shouldn't, right?
Right.
Explain that a little bit more, because I think that is something that's the mind-boggling piece to me, that this white grievance, this white innocence, this idea that even though they're still the majority in admissions, somehow they're being aggrieved and discriminated against based on being white or Asian as a proxy for them.
That's right. That's good. So post-racial constitutionalism is the answer to that. We want everything to be neutral. And the court, through its race jurisprudence, has really said that we're equal now. And so when we go down the road of looking at race for any purpose, it's going to be unconstitutional. There is no good use of race or bad use of race. It's too hard to distinguish between the two. Now, we can readily recognize that the state is doing something noxious when it places people in slavery or discriminates against them in terms of jobs or say they can't vote on the basis of race. But the court argues, it's not always that easy to distinguish benign discrimination, good discrimination, from malign discrimination, bad discrimination. And so the best way to resolve this issue is to say race should play no factor in decision making. So whenever there's this presumption that race is even being considered, like in the Harvard program, which had been affirmed over and over again, or the UNC program, then we say, well, the use of race is suspect. We don't care why it's being used. And since it's being used, it's going to be constitutionally invalid. The court always applies what we call strict scrutiny, the highest level of scrutiny to analyze the state action. And 9 times out of 10, we're going to declare it unconstitutional. They call it strict in theory, but fatal in fact. Whenever the court applies that, we are generally going to strike it down.
Yeah, and this I'm glad you brought up strict scrutiny, because I think, if I understand it correctly, the burden of proof or the burden of discrimination for African Americans or BIPOC people is very specific and historically located, meaning that it has to be something that happened during Jim Crow, versus when white people feel that there's discrimination, the feeling of harm is enough. Is that correct?
That is correct. And that's very interesting. There's a whole line of scholarship on that, how the pleading and burdens of particular plaintiffs based upon race seems to be lessened. And that's what you're getting at, that when it's a white plaintiff, the court readily embraces this notion of discriminatory impact. There is no rigid showing of discriminatory intent. It is purely, you must be aggrieved. This must be unconstitutional because race is being used. And think of all of the interlocking presumptions that there is. If you're using race, you must be taking a place away from a white person. The impact is real without showing discriminatory intent. And we're going to really presume that this action is constitutionally invalid. So what you're getting at is definitely the core of some of the court's race jurisprudence. Conversely, if it's an African American or person of color bringing a claim, they have to show clear, particularized discrimination. Discriminatory impact is fine, but that's not enough. You need discriminatory intent and discriminatory impact in order to have a valid claim of a 14th Amendment violation under the Constitution.
Well, thank you for that. And I think now is our chance to turn to the Honorable Justice Clarence Thomas. And
Yes.
we've kind of unpacked where John Roberts comes down on this and how his thinking of a, post-racial colorblind jurisprudence is located. But Clarence Thomas, always the vanguard, pushing the envelope a little bit further than anyone else. Could you explain to us what Thomas does in his concurrence and why it's so devastating?
Well, it's devastating because he has served this role for over 20 years in terms of the court's race and affirmative action jurisprudence. In previous writings, and indeed in this, and I reference him as the Black proxy. And what I mean by that is he is advancing this notion of post-racial constitutionalism because his Black voice on the court gives him authenticity. Now, we'll talk about Justice Jackson's dissent as well, because really that's the first time you have two African Americans on the court with dramatically different interpretations of American society discussing the issue of race. That in itself is historic, and that this opinion is historic for that reason. But Justice Thomas' concurrence is a form of post-racial deception. He is building upon the post-racial deception advanced by Chief Justice Roberts, where Chief Justice Roberts pretends that diversity isn't a compelling interest, that the previous decisions were wrongly decided because the court didn't give clear guidance. And now Justice Thomas builds upon that by completely rewriting Reconstruction history. So that's a deception in itself, by saying that the Reconstruction amendments were colorblind amendments, and whenever we enter race, it's going to be unconstitutional. So you'll notice when you read his opinion or any of his writings, he tries to apply everything generally. And that is a way of erasing race, erasing the anti-subordination principle. And I keep returning to this theme, erasing the anti-subordination principle, because he says that in his opinion. He calls the anti-subordination principle, since it's not explicitly written in the Constitution, he calls it a fad, that people are just popularizing this notion of anti-subordination when it's clearly a component of the 14th Amendment. That's what the 14th Amendment does. It eradicates the caste-based system in America, and it tries to make sure that African Americans are fully included. And so everyone recognizes that the 14th Amendment, 13th, and the 15th Amendment were race conscious. They come out of the Civil War. Even his opinion sort of erases the Civil War almost. He mentions it, yes, it occurred, but now we have this immigration program for everyone that really doesn't deal with race. So that's a deception. And then he does a number of distortions about that. But really, his primary role is to say that this is legitimate. There is discrimination. One of the last things in his dissent, in his concurrence, is that, yes, I recognize the problems of race, but that was kind of in a bygone era. And if we keep embracing this, we are going to have a society that's divided by race. And we want something more than that. We want an inclusive society. Yeah.
Right. And you call it his whole project a postmodern redemption. Mm-hmm. And if you could tell us what that means, because I think it picks up on, as you said, he's erasing huge swaths of American and racial history, which the South tried to do immediately after the war, right? So,
yeah, that's exactly it. Immediately after the Civil War. So there are a number of historians that you interviewed. Eric Foner, he does this work. Pernell Joseph does this work. they talk about how the Reconstruction era lasted only a few years, 10 to 12, maybe 13 years. But there was this massive campaign to re-envision the Civil War, to romanticize it, to redeem the lost cause, to make it as if slavery really doesn't exist, but what we were fighting for was states' rights. That resonates today. Our way of life, our culture that is being undermined by this forceful hand of government that seeks to crush what we know and what is unique. And so there's this whole enterprise after the Civil War by a number of historians to reclaim what the Civil War meant. And so they tried to redeem the nature of the war and what caused it, and really romanticize it. In some ways, well, in a lot of ways, Justice Thomas is doing the same thing. In these times, we want to fight for cultural awareness that brings everyone in, and that means we have to erase any reference to race. We have to reinterpret what diversity means. He claims he doesn't even know what it means. And we have to sort of look at neutral rationales for the inequality that exists. To Justice Thomas, a lot of this is individual personal choice. You can't have society coming in and imposing its will, that's a redemption thing, on society in order to reach a racial result. And so he's constantly pushing that thing. So that's what I mean by postmodern redemption. Yeah.
And then I'm glad you kind of ended there, because Judge Jackson does something that is, as you say, historic. And she brings into her dissent the whole notion of structural racism, bigger systemic racism, and things, statistics are a big thing that Thomas took issue with. So yeah. If you talk about how Jackson dissents and then how those two have a conversation.
Yes. So good. So let me just point to Justice Sotomayor. We don't want to forget her. I'll just briefly. What she does, and they both are responding to Justice Thomas, what she does is give a full articulation of the anti-subordination principle. So she's answering him. Yes, there is this underlying normative principle of the 14th Amendment, the anti-subordination principle. Everyone knows that the Reconstruction Amendments were race conscious, and that is clearly understood. So she's pushing back on this notion of him giving legitimacy and authenticity to this contorted history that he advances simply because he's Black. Now, Justice Jackson's dissent is extraordinary. I say it's one of the first, it is the first, in my mind, structural inequality dissent in the court's history. Now, not to slight Justice Marshall, he does a little bit of that. There's a whole series of school cases, most notably Milliken versus Bradley, where he talks about the parameters of state power. And I'm sort of working on a piece on that where he's really talking about the interrelated relationship of local, state, and federal power in perpetuating inequality. So that's a form of structural inequality as well. But Justice Jackson's SSFA dissent is the first really full-blown articulation of structural inequality. And she does it by looking at John and James, which is interesting. And she talks about the intergenerational component of structural inequality, how inequality builds upon itself, reinforces itself, and advances itself based upon race and economics and other things. But she really makes a very forceful argument that the court's formalistic equality, assuming that everyone is equal in erasing race, is unrealistic in today's society. And she has the famous quote now of, "You're preparing them for life in a bunker rather than the corporate boardroom." And that is a very provocative statement, but one that is true, one that is forceful, one that understands the structural dynamics of systemic racism. And so she's talking back and forth with Justice Thomas. Justice Thomas is very dismissive. He says that her view is colored by a racial view of the world, sort of pushing back that we're far beyond that. Everything is fair. What she's trying to do is unfair by talking about race, another form of inversion, turning it inside out. We can't even talk about race because it perpetuates inequality. And so their discussion is about does discrimination exist? And Justice Thomas would say, yes, it exists, but people make choices about how they interact. And he even says that discrimination can happen on a number of different levels. There are many types of discrimination. And so he always goes back into what we call liberal individualism, that this is a result of individual choices, and the Constitution protects individuals, not groups. And so the individual has the right to be free from discrimination from the state. And whenever you think about race, we're back to that again, it's going to be unconstitutional.
Okay, so we've walked through it all. How do you see this court under John Roberts made up of these justices? I'm going to ask you an unfair question. To predict the future and to say what is in store for this racial, the Civil War amendments. Are we looking to completely strip them without, recalling them or, retracting them? Or what is the ultimate project of this court? And where does it end, just as though they would say racism ever?
It's an ongoing project of the court. The court has already scuttled so much. We haven't even talked about voting rights, but that's a clear example. Shelby County in 2013, that is an extraordinary example of the court saying, okay, there was racism at one time. You can't show us how it exists now because we believe that we're post-racial, and any use of race is unconstitutional, so we're going to scuttle the Voting Rights Act, 1965. We don't even need to reauthorize it because you've had Black mayors, you have Black senators, you've had Black president, and so any consideration of race there would be trying to reach a racial result, rig the game with race, and that's unconstitutional. So we've seen the court doing that again and again. And so the Roberts Court is almost 20 years old now, I think. That has been their enterprise, post-racial constitutionalism, starting with parents involved, that the only way to move beyond discrimination is to stop discriminating upon the basis of race. So that has been their project. So in voting rights, the court has done that. Housing, the court has done that. Affirmative action, the court has done that. And every time the court is expanding this notion of what neutrality is. So I hate to be dismal or unduly pessimistic, but this court is not receptive to any positive remedial efforts. And even if it was, it would be so narrow that it's only incremental change. We have a 6-3 supermajority, and we have 3 justices, Kagan, Sotomayor, and Jackson, fighting a good fight. But it's very difficult when you don't have that swing vote, in quotation marks, like you used to, starting with Justice O'Connor and then Justice Kennedy. Now there is no swing vote. I think the court is so conservative now that Chief Justice Roberts may be considered the relative swing vote, and he isn't receptive at all to this notion of considering race. So it's very difficult. It will be very difficult. And I think generational damage has been done, and so it's just going to take a generational response to the court's race jurisprudence to bring us back to where we were, which was okay, not great. And then we have to start moving forward again. There's always this thing called retrenchment and retrogression. Whenever positive change is made, we have retrenchment and retrogression. And that's what we're in now, and the court is actively engaged in that enterprise.
Thanks for listening to the Unpacking 1619. For more information on Heights Library's 1619 Project discussion group, or to check out more interviews with scholars, please visit heightslibrary.org. See you next episode, wherever you listen to podcasts.